Hi, I'm Jared Faltis. I'm a CPA and a partner with McMill CPAs and Advisors. And today we're going to go over HR do's and don'ts in today's COVID world, which I think is a very timely topic for everything that's going on in the world today. And really, potentially, we probably should have done this maybe a couple months ago, but it's never too late to brush up on HR and things like that. So with that, I'm going to kind of introduce really our roundtable here. And I have Andrew Steffensmeyer. He's a CPA with us, and he's going to be talking about some of the tax credits, the basics of those, to make sure that we're not missing anything there. And then I have the pleasure of introducing Aaron Clark. Aaron's an attorney with McGrath North out of Omaha, and McGrath's been a great partner when it comes to some of the issues related to HR and especially COVID. So welcome both Andrew and Aaron. Thanks for being on.
Thank you.
Thanks.
So I thought it'd be good to really talk about the Tax Act and what's going on with the businesses, really employment related. And really there's two items that we need to talk about. One is the whole PPP. I know we had a webinar last week that we went over the PPP in detail, PPP round 1, round 2. So if you want to watch that webinar to brush up on PPP, that's really been the brunt of our questions probably the last couple weeks, is just making sure that the businesses are eligible for this another round of PPP. So with that, Andrew, if you want to kind of go into a little bit of the basics of PPP round 2, knowing that we have that webinar out there as well, showing the detail on our website, mcmill.info.
Right. Yeah, so I'll walk us through everyone's favorite 3-letter acronym, PPP, it seems like, in the last year. So yeah, like Jared said, we do have that webinar on our website that will go into more detail on the PPP. But for the most part, PPP round 2 is any borrower who applied the first time. If they would like to go back, there's really a major test that we have to do, is 25% reduction in your gross receipts from any quarter in 2020 compared to that same quarter in 2019. So I know there's a lot of question out there, what should I include in my gross receipts and what I shouldn't. So really our stance is we just need to be upfront with whatever bank you're applying with, just to see any kind of state of Nebraska grants that came out in August. Let's let our banks know that those might be included or excluded from our gross receipts number, as well as some of the medical providers. If you're getting Department of Health and Human Services grants, we just need to be upfront with our bank to let them know if we're including that or if we're not including that, because it seems to be a bank by bank basis. So again, we need to calculate that 25% of gross receipts for any quarter in 20, and we're going to compare that to the same quarter in 19. So again, as you see here, our idle money, any of those advances you received, and any PPP proceeds you received from the first round should be excluded from these gross receipts. And again, there's some different basics on what time period to use, so if you're in existence or if you weren't. So again, those details will be in our first webinar that we did on our website. And then if you keep going down here, so really our first test is, do we meet this 25% reduction? If we do, we can either use our 2019 or our 2020 payroll costs to go back for a second round. So again, that's going to be the same calculation as the first round, except if you're a restaurant, hotel with that NAICS code of 72, then you can actually take 3.5 times your payroll cost. So giving a little bit of an extra bump to those folks in restaurants and hotel industries.
I think one of the biggest things that I see too is, one, do you include those grants or not? Like Andrew is talking about, that's the biggest question. And like Andrew is saying, go ahead and just talk to your bank. It seems like most banks are being flexible and just saying, go ahead and apply and back those out. And defining receipts, is that more operational related? I think another thing is this somewhat of a last bullet item about receipts. All revenue in accordance with the entity's accounting method. We've had some inconsistency there. When you're on a cash basis, most taxpayers are on a cash basis when it comes to small businesses. And you want to make sure that you're looking at cash basis when it comes to receipts. You want to make sure those two mirror. Sometimes you're pulling up QuickBooks or whatever accounting software you're using, and it automatically pulls up accrual and using accounts receivable and things like that. So you just want to make sure that you're talking the same language when it comes to a tax return to what you're reporting to the bank to see if you qualify for this PPP number 2. Is there anything else to add on this, Andrew?
With the 25% drop in receipts, banks will be asking for this document, whether it's an income statement from you. So the SBA is saying if you have a loan of 150,000 or lower on your second round application, only the bank needs that to kind of cover them. If you have a PPP round 2 loan of over that 150,000, you will have to submit that to the SBA. So I guess one caveat there, but other than that, no.
Well, let's, knowing that we kind of covered the PPP in the prior webinar, let's dip into maybe one of those that aren't covered as much, and that's the retention credit. Let's talk about that a little bit.
Sure. Yeah, so employee retention credit, we kind of call it the ERC around here. Back in March and April when all this, CARES Act legislation was coming out, really it was, do you want to do the PPP or do you want to do the retention credit? Because you could not do both back in March and April. So, this latest legislation at the end of 2020 is actually going to allow you to go back and, use one set of rules for 2020 to see if you're eligible, and then use a different set of rules if you're eligible in 21. So, the biggest change is now you can retroactively go back and apply for this retention credit on your Form 941, those payroll returns each quarter. There's kind of a set of 2020 rules and a set of 2021 rules. So, basically, if you were involved in the PPP, the first draw program, you can actually go back and use any payroll costs that was not included on your PPP application, or your payroll expenses that were not used on the first application. You can use those to calculate your employee retention credit, retroactively looking back. So what they say, if you can use it or not, it depends which quarter, and you have to meet a 50%, 50% drop in gross receipts in that quarter you're applying for, or you were temporarily shut down. So at the bottom of this slide, it'll go through a few of those industries that were shut down, such as salons, massage therapy, any kind of medical practice as well. So that's kind of the 2020 set of rules. It's either did your revenues fall 50%, or were you shut down fully or temporarily? That's the 2020 rules. 2021 rules actually are more favorable. So again, that's just a 20% drop in revenue for one quarter. And then, also if you were shut down partially or fully. And so that's going to be, going back to 2020 rules, you get a credit of 50% of the wages you paid to employees. And then the 2021 rules is actually, it goes up to 70% of wage credit.
I think one of the biggest things that's maybe the confusion, once again, we're always waiting for more clarification. But if I'm a business that either was partially shut down, and I'll pick on a medical provider, and I feel that, I qualify for the PPP number 1 draw. I'm going to qualify for the PPP number 2 draw in the second quarter is typically what we're looking at for most clients. And hey, by the way, I was partially shut down, whether it's, the Health and Human Service Department came in and shut down my elective surgeries, who knows what, then I qualify for the retention credit. There's really a kind of a cloud of uncertainty if you applied for forgiveness in the PPP number 1 draw, and you put down all of this payroll as being forgiven. Does that take away your opportunity for retention credit? And that's really we're unclear about that. Ideally, if you did not apply for forgiveness and you have the choice of putting down rent and utilities and things like that to ask for forgiveness, that would be better. So if you're not in that situation yet, you haven't asked for forgiveness, that might be something to consider, is asking for a different type of forgiveness using those other expenses.
Right. Yeah, that's kind of the name of the game right now. We're almost postponing filing these ERCs, or these employee retention credits, on our 941 payroll forms until we have more guidance from the IRS as to, what payroll goes to PPP, what payroll is eligible for the ERC. So I think we're trying to get past January and even a couple months from now until until we have more guidance, and then we can always go back and amend 2020 payroll forms and get that money back as a refund. So not a huge rush on this, as we do have a lot of information still to come from the IRS there.
Well, let's go through the family leave and sick leave, and then we'll definitely turn it over to Aaron to, we'll go over some of the details here, and then Aaron can speak from the legal aspect of it. So, Andrew, if you want to kind of talk about this, really no major changes, really just the extension is probably what we're doing, and kind of a reminder of what this even is.
Right. Yep. So family leave and sick leave, these were, introduced back in March with the Family First Coronavirus Act. So family leave, I'll just kind of take us through some of the, caps and wage limits. So that's going to be this paid, paid leave up to 12 weeks. It doesn't kick in until 10 days of unpaid leave. And then, it's capped at a wage rate of 67% of a daily wage, or $200 a day, or $10,000 per employee. And I know Aaron's going to go through, more detail on these, so I'm just kind of covering some of the wage limits. Sick leave, on the other hand, that's for 2 weeks. So typically, this is going to kick in immediately before the family leave. So, this is for quarantine, medical diagnosis, if you're waiting to see if your test results come back, any kind of caregiving. And that would be capped at that 511 per day, or 5,000 roughly per employee. And so there are different limits for caregiving, as you see there. That's capped at 2,000 per employee. And so, this new legislation at the end of 2020, you see that Consolidated Appropriations Act, that's basically saying, okay, these things still apply in up through March of 2021. So we still have a couple months worth. So kind of let Aaron go through that a little bit more in detail.
That's great. So really, these are the ways to pay for the program. Now let's talk about implementation, and we'll really turn this over to Aaron.
You bet. Thanks, guys. So, with respect to COVID, as you know, if you're in the HR world, it's been a learning experience over the last year. These paid leave laws have certainly been something you've had to navigate through. And as Andrew indicated, under the recent Stimulus Act that was passed, under the previous act, everything expired as of December 31st, and that is still the case. It has expired. But now you do have the right as an employer to extend it voluntarily if you choose to do it. If you jump to the next slide, I'll talk about some of the topics. So it's a voluntary choice on your part. So under this extension, if you choose to do it, it doesn't give employees additional paid leave. As Andrew indicated, employees are entitled up to 80 hours for the paid sick leave part of it, the emergency paid sick leave part of it. If they already got their 80 hours, that doesn't mean if you extend it as an employer, they're going to get 80 additional hours. If you provide those additional hours above 80, you're not going to get the tax credit for it. So it's only for those employees who did not use or exhaust their benefit in 2020 that you can still get the tax credit for those people. So it's a good thing that they're giving you the right to do that. Obviously, there's still going to be a lot of people contracting COVID over the next couple of months. It's still going to be a big deal in our world. So this gives you the right to still provide those benefits if you choose to do it and get the tax credit for it. And one thing you need to know is if you do it, just like the previous law that expired on December 31st, you still want to get that documentation from your employees, and you want to document obviously their names, dates of leave, and the qualifying reason why they're taking it. And there's several reasons that would qualify, and those are on the next slide. But basically you need to have a statement in the documentation that this is going to be based on a quarantine or an isolation order. The more common reason why people are taking paid leave, obviously, is that they either have COVID or they're subject to a quarantine because a doctor's telling them to, and that's under the second category. And that should be part of your documentation as well. And then the third category that Andrew alluded to is also if your child's school or daycare is closed and you still want to extend that benefit to them into 2021, you can do that. And the documentation should reflect those requirements. One thing you need to know, and I don't know how many people on the call are subject to the FMLA. As you may know, the FMLA only applies if you have 50 or more employees and the individual has been with you for over a year. These laws under the FFCRA don't have those requirements. But one thing you need to understand is if you have FMLA and your employees are eligible for FMLA, you've got to give them 12 weeks. And if you decide to extend the benefit into 2021 for the child care part of it, and you give them that leave, what you have to understand is that is not going to be taking away their 12 weeks. They're entitled to 12 weeks under the FMLA, and if you choose to extend it and give them more child care leave under the Act, they still have their bank of FMLA leave they can use. It doesn't go against that with respect to the extended leave. Now, if they used the child care leave back in 2020 and exhausted 6 weeks of that, well, then they only have 6 weeks of FMLA to use for whatever reason under the FMLA. But you just have to know if you extend it voluntarily into 2021, it's not going to take away their 12 weeks of FMLA that they're eligible for. Where it did count in 2020, it's not going to count in 2021. So I hope that makes sense. Mm-hmm. The topic that's really a big topic now in my world is vaccinations. And this is something I was going to talk a little bit more about. It's really a hot topic right now. Obviously, vaccinations are out there. They're not readily available to most companies and most employees. They're only available based on whatever the state identifies as the primary groups to get them right now. But the big question that we're talking about now on the next slide is can you require employees to get vaccinations? And with respect to that question, the thing you got to think about is why would you want to require it? First of all, there's a big liability concern for you as an employer. As an employer, you know that if an employee gets sick at work, if they get COVID or they get some kind of sickness or injury at work, and a lot of times they're covered by workers' comp. And that protects you as a company because workers' comp, if it applies, it prevents the employee from going to court and suing you under some kind of negligence theory or some kind of other theory, and they can try to recover damages for that. So as an employer, you want that protection of workers' comp. COVID is kind of a unique animal because if an employee gets COVID, that's not considered a work injury. Occupational diseases are work injuries. So like if you work in a factory and you breathe in chemicals all day and you get some lung disease from that, that is going to be covered by workers' comp. COVID is not an occupational disease. It's a community spread illness. And although you can get it at work, it's generally not an occupational disease. So what that means is you're not protected under the workers' compensation laws. And an employee, if they get COVID because of your negligence at work as an employer, they may be able to sue you in most states, including Nebraska as one. Some states have immunity protections like Iowa where you can't sue an employer, but Nebraska and most other states haven't adopted that, and they haven't adopted it at the federal level yet either. So you have some exposure there. So when you talk about vaccines, why would you want to do it? Well, you want to encourage it. You want to try to get employees vaccinated because it does protect you from liability and preventing you. And these liability cases that are out there now, what you have to realize, there's a lot of different theories. Most of them are negligence. And if you comply with the CDC guidelines and you have masks and social distancing and do all these things within your company, you should be protected from a negligence claim because you're doing all the stuff you're required to do. But that exposure is still out there. So that is a big consideration when you're talking about the vaccines. With respect to the vaccine, obviously, whether you make it mandatory really depends on your business. If you're a company that has to have people work in close contact with one another, and you think of a lot of different industries like the meatpacking industry. I represent a lot of meatpacking companies they're requiring it and they're making it mandatory. And their employees are, in many states, are considered essential to where they're going to get the vaccine before other people. So companies are looking at right now making it mandatory in those businesses. Obviously, healthcare, people are getting vaccinated in the healthcare business because they're the priority group right now. If you do a mandatory policy, one thing you got to think about is the EEOC. You have to carve out exceptions for people if they have a medical condition or disability and their doctor says that maybe they shouldn't be vaccinated. So you may have to grant accommodations based on the ADA and medical conditions. The other thing you got to think about are religious exceptions. If people have religious beliefs that are sincerely held and for some reason they can't get a vaccination or their religion prevents them from getting a vaccination, those are things you have to consider to accommodate. So even if you have a mandatory policy, there's going to be some exceptions you have to think about. With respect to OSHA, OSHA really hasn't taken a position yet on vaccines. Right now, OSHA says if you have a workplace, you have to provide a safe workplace. And that requires you to use PPE and masks and all these other things. They're not requiring a vaccination at this point. So OSHA just requires you to do what you're probably already doing. Again, workers' compensation, that can come into play with mandatory vaccinations. If you require employees to get vaccinated and they somehow get injured or they get sick, seriously sick from it or something like that, and of course that's not a real common thing, but because you're now requiring them to take the vaccination, it is a workers' comp claim. So you would have liability for people who sustain some type of injury because of the vaccine. And one other consideration you got to think about is the refusal issue, and that's really a practical issue as an employer. If employees come together, two or more, and they decide we're going to band together and we're going to impose this mandatory policy, and you fire them because they don't get the vaccine, or you take some kind of adverse action against them, that could be considered an unfair labor practice. So that can be an issue as well for you on mandatory. So if you go to the next slide, if you talk about mandatory or not, what should you do at this point? Well, at this point, it's really not readily available. So you really can't make it mandatory right now as a practical matter. But unless you're in certain industries where they're getting vaccinated at this time. But obviously, the considerations are protecting the community and employees. The big issue as an employer is if you're in certain industries and somebody gets COVID, it sometimes knocks out a big part of your workforce just because these people work so closely together. And if you have a job like that, if you're in the hospitality industry or the restaurant industry, those are the kind of jobs that sometimes it seems to be more of a consideration to think about those things. But what you need to consider also is employee retention and morale. I mean, some of the things we just talked about, you could have a lot of employees that are very opposed to it. And if they refuse or absolutely refuse, what are you going to do? It could be an HR burden for you because you're going to be disciplining or doing a lot of things that you may not foresee that might have to happen. But what we've been recommending to most of our clients at this stage is kind of wait and see whether the vaccine is going to be readily available. And when it is, then you got to make that call. A lot of companies right now, what they're doing is they're doing surveys because they know at some point they're going to try to decide whether to do a mandatory policy. So they're sending out surveys to their employees, questioning like, first of all, the company's considering vaccinations as part of your job. What are your opinions on the vaccination? Is this something you would do voluntarily with the company? And see what their workforce, just get a temperature of what they think is going to happen. Other companies are providing incentives or plan to provide incentives. For example, Dollar General store is giving 4 hours of pay to employees who get vaccinated. Some companies might, give you some additional paid leave or vacation or something like that in exchange for you going out and getting vaccinated. So there's a lot of companies looking at the incentive route as a way to do it. But the real takeaways from this is if you do make it mandatory, you got to make sure you have a policy that allows exceptions for medical conditions, religious accommodations. You want to really give employees advance notice of your intent to do that and maybe take a survey and feel them out for what they think about it. And you want to educate them on the vaccine because you want them to buy into this. You don't want them to be in that group where they're concerned about getting the vaccine and some of the horror stories you may hear about it. But, for the most part, everything out there is really showing it is a safe thing to do, 95% effective. If you do a mandatory policy, the thing you have to realize, it's not going to take away what you're doing now. You're still going to have PPE. You're still going to have to do all the things the CDC requires until we get to this point where there's herd immunity to a point where it's really safe not to do that anymore. The vaccine is not 100% effective. It's very effective, but there's still a low percentage there may not be. And there's still some questions about transmission of the virus, even if you have the vaccine. So from an employer standpoint, you're still going to have to do the same stuff you're doing for a long period of time, even with the vaccine. But it is something that you certainly can consider based on the nature of your job. So
maybe to recap a little bit, Aaron, from what I hear, and most of our audience is probably under 50 category. Yep. There are a few exceptions over 50. For instance, our firm is. And maybe one of the questions I have is there a difference between essential versus non-essential, or is it just kind of a blanket that, just a good business practice to maybe not force this, no matter if you're essential or non-essential, but to maybe better educate versus force?
No, an essential is really something defined, and it's going to be defined at the state level. As far as the vaccine goes, as you may know, the state, like for example, Nebraska, the governor's office right now gets to decide the priority levels for different vaccinations. And so they get to determine what essential jobs they think. And there's a lot of debate right now, what's an essential job and what's not. I mean, for example, my wife's chief deputy, Douglas County attorney here in Omaha, and she's fighting to get their staff in at a priority number because the courts are getting backed up. These criminal cases, these defendants aren't going to trial. So they feel that their job really requires that they get people back in the courts, and they need to get vaccinated to do that. So there's a big debate on that of what's essential and what's not. Most companies, as far as making it mandatory or not, it really is based on look at the nature of the job. Do people work together in close contact? And if they do, and that's like production environments, manufacturing environments, those are the people and those are the jobs that most companies are really thinking about making it mandatory because there is liability exposure for them. It's a greater liability exposure for them with people getting COVID. And with respect to these lawsuits, the thing that's interesting is as an employer, you need to understand, you're not just liable to your employee. If they bring it home to somebody who's vulnerable and that person gets sick and even passes away or dies, that person can sue you because you were negligent not protecting the employee that brought it home with them. So, those are the considerations you got to think about with respect to your business. If you work in an office environment, like I'm here in my law firm, I've got an office, I don't work around a lot of people, requiring a vaccination may not make a lot of sense to us. It may be more of an incentive thing that we're going to probably do at some point for people. So that's a good question.
Yeah, I've seen the list of essential, and I think everybody's almost deemed as essential. I'm not sure who isn't essential when you look at that list. So that's amazing what COVID does. It makes you kind of dig down deep and look at essential and all these rules. And fast forward, we're here today, and so I think you're exactly right. This is just something we're going to have to monitor the advancement of the vaccine, monitor how readily it's going to be available. And we're just going to have to determine as a business, does this make sense for our business or not? Yeah.
And another topic that I don't know if we have the time to talk about, I mean, it's not on the slides, but and many of the HR people on the phone, I'm sure, or on this call or whatever, probably have dealt with COVID cases over the last 8-9 months. But the things that are happening now, really, what I see a lot more with my clients are they're starting to get people back to work. There's been a lot of companies that have kept people out of the office for a long time, and people are starting to now being required to come back to work. And in connection with that, there's a lot of issues because a lot of people don't want to come back to work. Obviously, they've liked working at home. Can you force them to come back? Absolutely, you can, unless they've got some kind of disability accommodation issue they bring forth. And one of the things we're seeing, which is kind of interesting, is obviously people that have pre-existing conditions like lung conditions, heart conditions, immunity compromised systems, those people are protected, and you really have to look at accommodations for them, and it may include letting them work from home for an extended period until things are better with the pandemic. But one of the things we're seeing a lot of are people with anxiety and stress. And these companies we've gotten a lot of companies dealing with, employees bring in a doctor's note that says, look, Joe Smith suffers from anxiety and stress. And if you force him to come back to work, he's not going to be able to do his job. His condition's going to increase to a level where he's just not going to be able to focus. He's not going to be able to do his job. And you need to accommodate him and let him work from home a little longer. And then, so we get these questions of what do you do? I mean, can this be a disability? Yeah, it could be a disability. But, what can we do to accommodate these people? And sometimes, you can be aggressive as an employer, and you can push the envelope a little bit. And I've had cases where, your obligation under the ADA is you got to meet with this employee and go through an interactive process and talk to them about their condition and their concerns and what are they concerned about. And then if you can reassure them, look, you know what, we've got safe practices here. We don't have a lot of COVID cases. We social distance. We wear masks. We'll give you your own office. We'll let you have an area where you work away from everybody. We won't have personal contact. We'll do everything to reassure you that you're going to be safe coming here to work. And if you can provide those assurances and accommodate them in that way, you may be able to get them back to work. And I've had cases where we've basically set deadlines for people to come back to work, saying, look, we've got all the safety measures in place. We've talked to you about it. You understand it. You're safe. And they don't come back. And then you have to terminate them. Mm-hmm. But those are really a lot of stuff that we're seeing now. Is there's a lot of anxiety and different issues that medical providers are providing doctor's notes for. So it's kind of interesting.
Yeah, I agree. We did have a few questions.
Okay, great.
Some of these, are probably related to, just you kind of have to think about the client just going through what they've gone through the last year. And some of these probably could have been asked, maybe 9 months ago. But is there any reason not to adopt the family leave and sick leave as a small employer? I would think, is there any reason why you wouldn't want to adopt that?
Well, last year, that was the question, and if you're a small employer, your only way out of it is if you can show it's going to affect you to a financial point where you can't do it. You just can't pay it. You can't do it because there is an exception under those FFCRA. If you're under 50 employees and you're a small business and you can show the financial burden, you can be accepted from it. But that's the only way you get out of it. Obviously now after December 31st, you're not subject to it. There are a lot of states that have paid sick leave laws aside from COVID, and Nebraska is not one of them, but and they don't have them in Iowa either. But with respect to a lot of states, they do have paid sick leave that you have to provide employees, which would cover COVID. Colorado even has, I think, an emergency COVID paid sick leave where you have to give a certain number of hours to an employee. And this is aside from the federal requirements, which are no longer in effect. So,
as far as documentation, when it comes to, if the person says, you know what, I'm showing symptoms, or I feel like I have symptoms, and they call HR, what is HR's general response? If you could just kind of talk about that, just to kind of boots on the ground.
Yeah, sure. That's a good question. With respect to COVID, as everybody knows, in most cases, it's a minor illness and people recover from it really quickly. So so the first approach when somebody calls you and tells you I have symptoms, you don't want them to come into the workplace, obviously. But I think your first response is that's your assumption. It's going to be a minor illness. They're going to be able to come back to work, and you're just going to treat it like any sick leave issue. Employees can use their sick leave if that's available or whatever policy you have, PTO or whatever, since you're no longer subject to the paid sick leave stuff. But if it becomes more serious and they're out for a lengthy period of time, beyond beyond the 10-day quarantine, right? You're going to place them off for at least 10 days, 14 days. If they have COVID, I think it's 10 after they start symptoms. So you're going to follow the CDC guidelines. And after that, if they're still off work and they're still suffering from this illness, at that point, I would ask for a doctor's note, a medical provider, and tell them that, look, we need to get similar to FMLA. If you're not subject to FMLA, you don't have to do this, but as an employer, you're still going to want to get some information from the doctor regarding their status, how long they anticipate they're going to be off work, and then you're still going to have to accommodate that for it could become a disability. COVID is not a disability, unless it becomes more serious and it becomes more of a permanent thing with a lung condition or something like that. But so after those 10 days, as an employer, it should be on your radar to get some kind of medical documentation to find out how long they're going to be off work and what the prognosis is going to be, so you can manage, your workforce. So
let's talk about a situation. This is a few questions that clients had not too recently, and so employee E calls in and says, I think I have symptoms. Symptoms could be a common cold, could be fever, could be anything. And, of course, HR responds, stay home. What if they've used all their PTO and employee says, hey, I want to get paid because I know you got this, it's pretty well on the street that, FMLA, the family leave, sick leave is out there. What does HR do then, I guess? So this person's staying at home, maybe somewhat willing, unwilling to get tested, who knows what. Can you kind of explain that scenario?
Sure. I find the best policy and practice to have is once you've provided the paid leave to employees, and I've had multiple cases where clients have called me and said, look, this is the 4th time this person's been quarantined, and I'm tired of paying them, and they keep going out and doing things to put themselves at risk. And the best way to address that is you don't pay them. Paid leave is done. They can use their PTO. Once they burn that, you don't pay them, and that's the best way to try to get them back to work, because there is a lot of abuse coming out of this, unfortunately, and it's hard to sift through the legitimate cases and the ones that aren't. But that's the response is to at some point you got to cut it off once you provided your paid leave, and you want to help employees, and you got to be consistent too. I mean, you can't pay some people and not pay others. So you really want to, if you're going to draw the line at some point, if you've been paying people in the past, you really need to communicate. You're going to stop. This is what our policy is going forward. You use your PTO. Once that's exhausted, we're not going to be able to pay you anymore after that.
I think the best way to describe it is you have an HR issue first and foremost. And really the family leave, sick leave is just a way for the employer to get reimbursed to handle that situation maybe. Yeah. But really, it's really is it right to describe that really that's not the right of the employee? Or that is it right to say that you have an employer-employee relationship, whether the employer decides to get reimbursed or not from the government? Isn't that a separate issue?
It kind of is, yeah. And the reimbursement only goes up to the 80 hours. So once you give them the 80 and you're required by law to do that, you can't get the tax credit for anything above that. So, from the employer standpoint, it's really coming out of your pocket at that point if you pay them. And a lot of companies do it. A lot of companies they just err on the side of protecting their workers, and they want to encourage people to be off work. They don't want them taking risks by coming in, and that makes sense. But it has. I've just seen a lot of abuse recently, and the best way to get people back is to just simply, deny it, and that's kind of the thing you got to do. So.
Is there any special, documentation when it comes to, say you got that employee that doesn't want to come back to work like you described, who knows what the situation is, but just is unwilling to come back to work because of, various different situations. what does an HR make sure that they document in their files to make sure that they're doing the right thing? And maybe you're going to point out that COVID's really nothing special from an HR standpoint, treated like as normal. But is that kind of your general response?
Yeah, and like I said, if it gets past the period where they're supposed to be back to work and they're still sick, then I think at that point the documentation goes out. And one form that we use, a lot of our clients use, is it's kind of it's an ADA inquiry type accommodation form, and you send that out and you have it filled out by their doctor, and their doctor will, identify the condition, any restrictions, dates they're going to be able to return, if there's going to be any kind of restrictions or accommodations when they return, what those are going to be. And then you want to get that documentation in place first. And then after you get that information back, the general procedure is you meet with the employee and you go through this interactive process where you talk about any restrictions they want if they come back, and see if you can do it. It really is an accommodation analysis at that point. But yeah, the documentation should really kick in with respect to COVID after the quarantine period expires, and this person looks like they may have more of a long-term issue coming back to work. So.
Is there any other, I think we handled all the questions that I had. Is there any other comments maybe about what HR and owners should maybe be looking for, maybe in the future, or maybe now?
Yeah, I mean, this pandemic's going to be with us for a while. With the vaccine coming out, some people think, well, at some point we're going to be able to get rid of all the PPE and let people come back to work and everything's going to be normal again. It's just, even after the vaccine comes and people get it, it's not going to happen for a long time. And so I think you still got to enforce those practices and still realize there's liability out there. You're not protected by workers' comp in most states. And until at the federal level, that they get to a point where they can pass some kind of protection, liability protection, immunity, which, right now Congress has always been Democrat versus Republican. Republicans have been in favor of opening business, letting employers have immunity, protecting them from liability, whereas on the other side, the Democrats have said, well, it's a safety issue, and if you let people have immunity, they're not going to ensure a safe workplace. So that debate has gone on, and that's prevented them from getting anything passed. And now with the new administration, I don't think it's going to ever get passed. So what that means is you are going to have liability exposure out there for a long time, and you need to just still keep those places, keep everything going that you're doing now, and make sure you're protecting your workers.
Mm-hmm.
So that's probably the best message right now.
From a posting standpoint, posting on doors and bulletin boards and whatever you want to call it, what's the general practice there?
You mean as far as COVID and things like that?
Right, educational materials / CCC.
Yeah, you should have a policy, a COVID policy about what it's a health and safety policy relating to COVID, outlining everything that you're doing, expectations if people are sick and symptoms and what they have, limiting people close contact in the workplace and conference rooms. You should have a policy that addresses all that stuff, and it should be. Hopefully, you've done it already, and if you haven't, you should definitely think about doing it. So employees clearly understand it, and posting it is a great idea, but it should be distributed to all your workers. And we've done that for a lot of our clients, putting those together.
So are you encouraging to kind of beef up the company handbook for a COVID policy specifically? Or do you think the standard sick leave, family leave covers that?
Yeah, I mean, as far as putting in the handbook, you certainly can, since it may be a policy that someday you're not going to need so much anymore. Most companies have just adopted it as a separate policy from their handbook and done it that way. But it is something it's going to be treated the same way as any employment policy in your handbook.
Sure.
For enforcing it. And that's it. You got to enforce it. I mean, you see people not following the rules. That's going to make you liable. I mean, you can have all the policies in the world, but if you're still letting people walk around without a mask and interact with their coworkers in their office, and somebody gets sick, brings it home to somebody, yeah, that's a serious concern. It really is. So you got to make sure you're enforcing it as well.
Mhm.
I had one question. If an employer decides to keep the family and sick leave going through March, what kind of communication to employees do they have to have?
I think it can be a real simple communication. The first thing you got to realize is you can't pick and choose who you're going to let it apply to. You have to do it. I think the best practice is do it for everybody. You avoid discrimination, unfair treatment issues. You know, some companies have asked me, since I've had some employees who have abused this type of leave in the past, can I not provide it to them, but just, you know, extend it for other people? And I'm not super comfortable with that. But with respect to the communication, it's just, you know, the companies may have already had a communication about it, maybe just a general statement that, you know, employees will still be eligible for the FFCRA benefits through March 31st. We're going to do it and put the deadline on there. And you can just, it's just that simple. I mean, I don't think you have to say much more than that, just so they understand they can use it. And again, that only applies to the people who haven't used it yet. And that may be something you need to say too. We're not granting you an additional 80 hours. It's for those people who haven't used it yet.
Mhm.
So.
Good.
All right, anything else for the group?
I don't think so.
I think we covered it. So
All
with
right,
that,
great.
I guess I'd like to thank Aaron. I'd like to thank Andrew for being on the call. And once again, the participants on this call, if you have any questions, please reach out to us and we can definitely forward on questions to Aaron if needed as well. And please check out our website here. We'll try to put any resources that we feel are relevant to HR, to tax credits, to tax bill, stimulus. There's probably more stimulus money coming. Who knows? So we'll find out tomorrow and we'll find out the next day, and that's the way it's been. So with that, we'll close the webinar, and thanks for everybody attending.
Thanks, guys.
Thanks.